Michael.
My Lords and my Lady, yesterday afternoon I spoke of there having been much movement in the appellant's case in the course of the submissions that Mr. Eadie made in the course of the day yesterday. Before I embark upon my submissions, I would just like to trace, if I might, the movement which took place. The case that was put in writing in the appellant's printed case distinguished very, very clearly between the defence and the non-justiciability rule. And we can see that in summary form in the summary at paragraph 9 in the core volume, page 12173. Where at paragraph 9.1, the appellant said this: Crown Act of State comprises a tort defence which applies to acts of the executive performed abroad in the course of its foreign relations, including its relations with the subjects of foreign states, pursuant to a deliberate UK foreign policy, as well as a non-justiciability rule. So the non-justiciability rule clearly identified as something different, and that is then described in subparagraph 2. The non-justiciability rule prevents the domestic courts from taking cognizance, that is, asserting jurisdiction, in respect of a certain class of sovereign acts executed by the UK government in the field of foreign relations. So we have two very, very distinct concepts, and we can see that in paragraph 49, 12193, the defence was not limited to military operations. So first of all, McNair is cited, and we can see the breadth of the defence described by Lord McNair. Its scope of operation is the whole field of governmental or official activity in relation to the Crown's dealing with foreign states. And the form assumed by it is for the defendant, if so authorised by the appropriate government department, to plead act of state, i.e. that the doing of the act or the making of the omission complained of by the plaintiff was the defendant was acting in an official capacity. Then there is reference to Lord Wilberforce's definition. And we then see that on the next page in paragraph 52, the appellants note the suggestion of Mr. Justice Leggett that the defence might further be confined to military operations, that is, acts using the use of military force, and the appellants did not. We can see 5 lines down, whether or not the defence is confined to acts involving the use of military, it applies to each of these appeals which not only concern such acts, but involve the use of military force during the course of armed conflict. So they don't even accept there that this is a defence which is confined to the use of military operations. Yesterday, Mr. Eadie conflated these formerly two distinct doctrines. He told us they were, in fact, two ways of describing the same thing. And in so doing, he fundamentally narrowed the scope of the defence as they had formerly characterised it. It's no longer an act of the executive, a simple act of the executive, pursuant to a deliberate foreign policy. First of all, he questioned whether or not any role fell to be played by the use of the term deliberate. But more significantly, he narrowed the sorts of acts which the defence can capture. So now it is a defence which arises only in respect of sovereign acts. Now, sovereign acts are not defined by Mr. Eadie. They're partially defined in that he identified sovereign acts with the kinds of acts with which the courts were concerned in the Camachi case when they were looking at the non-justiciability rule, such as treaties, annexation, declarations of war. But in the context of declarations of war, on his conceptualisation of the defence, it doesn't just capture declarations of war, it captures the conduct or acts done by the executive in the course of military operations. So we go from these very high-level policy acts of the executive down to acts done in the course of their execution, which is a narrowing of the original conception of the defence, which was defined simply by reference to the fact executive acts were taking place in the field of foreign relations. But nowhere...
Are you suggesting that the conduct of military operations is not an executive act?
Oh, it's certainly an executive act, but the question is whether it's a sovereign act as defined now by Mr. Eadie as a condition precedent for the application of the defence. So initially, Mr. Eadie characterised the defence as one which applied to any act of the executive in the field of international relations, as long as it was done pursuant to a deliberate government policy or ratified. He's narrowed that now because he seeks to equate the defence with his conceptualisation of the rule of justiciability, which was itself limited by what he called sovereign acts. Now, sovereign acts and executive acts are not the same thing in his definition. He has limited sovereign acts to those acts which are in the nature of, or were seen to be in the nature of, non-justiciable acts by the court in cases such as Kamachi. Very specific sovereign acts, such as declarations of war, entering into treaties, and the recognition of foreign states, for example. Now, those are subcategories of executive acts, but they are not the same as executive acts in the field of foreign relations.
I'm a bit puzzled about this. I mean, apart from the question whether it's archaeology of the arguments is really going to be ultimately productive. If you look at paragraphs 66 and 67 of the Ministry of Defence's case, which is certainly dealing with the tort-based claim, because paragraph 69 goes on to deal with the non-justiciability rule. And if you look back over the previous paragraphs, you can see that it's dealing with the tort defence. There is specific reference in 66.1 to the concept of sovereign acts performed on the international plane. At the end of 67, the summation is, it is a defence or special rule governing the allocation of jurisdiction which may apply where the act is essentially an exercise of sovereign power, such that it falls within the sphere of international law rather than municipal law. And I mean, that's really why I asked Mr. Eadie in his argument, what was the cigarette paper which lay or could be put between the two branches of what Lord Wilberforce thought was, in origin, a single rule, and which it's quite difficult to find as two rules in Buren and Denman. It seems to me that's really what we ought to be talking about, whether there is... it may be there's been some inconsistency in the argument, but at the moment I don't see it.
Well, I'm content then to work on the basis that my understanding has been mistaken, and in fact there has always been, despite the fact that these were characterised as two completely different things, they in fact were always intended to describe the same thing. Yeah. On the assumption that they were intended to describe the same thing, Mr. Eadie yesterday appeared to move in this respect, and this arose in relation to a question that Lord Mance put to him. He appeared to accept a further qualification on the acts which are capable of constituting this defence or rule of justiciability, and that was as to whether or not in acting in the course of its military operations, the Crown was acting consistently with international law. Now, we didn't get to a clear answer as to what Mr. Eadie's position on that was, but if Mr. Eadie meant to accept that if and insofar that the defence will only apply and an immunity will only be conferred in circumstances where the executive acts not only are within the scope of broad powers given under international law, but are in conformity with the way in which international law circumscribes those powers or obliges the state to act, then Mr. Eady has reached a position which is precisely that which we are contending for.
Well, I didn't understand him to be making any such submission.
Well,
He made submissions about whether it made sense to distinguish in this context between powers and obligations. But I didn't understand him to be limiting it by reference to international law at all.
Well, that is... so the question began, and then there was a conversation or a discussion between my Lord Sumption and Mr. Eady, and I agree that the discussion then moved away, and there never was, in fact, an answer to that question. So I'm proceeding on the assumption and on the basis that he hasn't made that concession, but it would nonetheless obviously be interesting to explore and reply precisely what his position is in relation to the significance of compliance with international law.
Yeah, I think your case, though, which I certainly put to Mr. Eady, is that it would have to be compliance with an obligation under international law, whereas I think what I was putting, and Mr. Eady said might be an interesting thought, but I don't think he accepted it or tied himself to it, was that it might be sufficient if it was not inconsistent with international law, without there being any obligation.
I mean, one of the troubles with this is that looking at the authorities and what's been said about them, it would be positively surprising if cases on this difficult topic didn't change as they went up the courts, went through the courts. Yeah. Question for us is, what's the right analysis today?
Yeah, absolutely, and there are other respects in which the case has changed on the part of Mr. Eady, and I'm going to take the case as he puts it now.
I think that's probably the most helpful thing to do, although looking at what it was before may help colour one's view or may inform certain approaches, but in the end, the fact that it changes is of itself not a sin. It might be said to be a positive sign.
Well, it's positive in the sense that what it reflects is a recognition that the case that was put before can't be justified according to...
Well, no, it's more that the case gets refined. This is a difficult area, and I think on the whole it's helpful to concentrate on where we are now.
One also has to be a bit careful about pot and kettle, doesn't one? This may be unjustified, but I was reading the habeas corpus Ramatula judgment overnight, and I noticed that those on your side at that stage were quite content to accept that what had happened by way of detention was in accordance with international law. There was no suggestion there. I'm not suggesting it's issue estoppel or anything, but the case was conducted on the basis that the detention was in accordance with international law. There was no suggestion to the contrary.
Well,
so.
Let's concentrate on where we are now.
Yes. Can I just clarify the way in which we do put our case? Because I fear from the observations Lord Mance made about it yesterday that we haven't been clear enough in what we are actually arguing. So our position is, and we'll go to where we set it out in the printed case, but our position effectively boils down to this. Yes, there is a principled justification for the court standing back and refusing to give effect to municipal law, and really that's whether it be foreign law or English law, in relation to the law of tort, in circumstances where what the executive is doing abroad is done in accordance with international law. That is, where it is done in accordance with the powers that are conferred under international law upon the United Kingdom, but also in accordance with the way in which those powers are circumscribed in international law. So, for example, if we look at the context of detention, it's now clear in the face of the case of Hussein, which in our submission Mr. Eady mischaracterised yesterday, that international humanitarian law does not stand alone in regulating the internment of individuals during an international armed conflict, but it is modified by human rights law, by the European Convention on Human Rights. And so if and insofar as the United Kingdom has interned individuals in accordance with the powers given to them in international law, that is, the executive would argue, for where it is necessary to do so for imperative reasons of security, and that is also done in accordance with the obligations cast under Article 5, then that would be a justification for the court standing back and saying, we are not going to require or adjudicate upon this case by reference to a municipal law tortious framework. That's our case. And we'll come to the justification for it later.
That's a reference that you said Hassan.
Sorry, Hassan.
Yes,
Hassan.
Hassan.
Hassan in the European Court.
Quite. Yes, no, we...
Now, can I just for your lordships and my lady's pen, tell you where we make reference to powers and obligations as opposed to just obligations. It's in the Statement of Facts and Issues. There are a number of those, but one example can be found at page 12167, and it's in...
Yep.
That's in the Statement of Facts and Issues in relation to the Iraqi civilians, paragraph 51.
Yep.
Subparagraph 5.
Yes. Authorised or required. Yep.
Authorised or required. Similarly, in our case, at paragraphs 205b, 280, 213, starting on pages 12329.
Yes. Thank you.
My lords and my lady, we have copies. Mr. Eady has produced copies of Hassan. I think my lord Clark asked for a copy.
Yes, I should certainly like to see it.
If you haven't got enough for all of us, that's fine. I just want to send the usher round if you haven't got them.
Well, we've got masses if you want them. The Lord Clark he didn't have the
Oh, I see. Yes. No. It's in.
One will be good enough for me.
It's in the additional bundle, is it? Sorry. No.
No, it's in the previous bundles, which we don't always bring
No,
with us unless we are warned so to do.
No, we don't have it. Yes, sorry. Sorry, Derek.
We've got lots.
Okay, we carry on, Ms. Kaufman.
So, putting aside whether there's been any movement, the doctrine, which the appellants contend can either be looked at as a rule of justiciability or a defence, is subject to two purported justifications: the one-voice principle and that these acts sound on the international plane and ought properly to be judged by international law. But what we do not have, according to Mr. Eady's conceptualisation of what is court, is an explanation or an identification of the criteria that enable the court to decide which acts done in the course of the United Kingdom's military operations are caught by the immunity in pursuit of those two purposes, and which acts are not caught by the immunity. And there was some discussion yesterday about potential examples of cases which might fall on one side of a line or the other, but an absence of criteria by which to be able to decide on what side of the line they fall. So we are no closer to knowing which acts that are not themselves declarations of war, those sovereign acts of clear high policy or the making of a treaty, are caught by the defence and which are not. And in the end, abandoning any reliance on these purported justifications, the one-voice principle and the international law is what regulates principle, Mr. Eady said the real question is, in this sphere, is it appropriate to subject the United Kingdom in the field of military operations abroad to local law? And as I've said, the problem is the appellants have given the court no tools by which to answer that question. We, by contrast, seek to analyse the relationship between the executive and the courts in the field of foreign relations in a principled way, in a way that is firmly rooted in a modern constitutional framework. By that, I mean a framework that recognises the proper modern limits of the institutional competence of the executive and the judicial branches of state, according to the separation of powers and the modern reach of the rule of law and the right of access to the courts. Our approach properly reflects what the courts actually do today within that modern constitutional framework and is consistent with what they do. It is an approach which requires justification of any judicial abstention to be firmly established as necessary and proportionate in pursuit of some identified legitimate aim. And it is an approach which has full and proper regard to the importance of the executive being able to fulfil its obligations in international law. And it will become apparent in the course of our argument that there is an important symmetry and commonality between the arguments presented on behalf of Mr. Belhage back in November on the issue of the doctrine of foreign act of state and the arguments that we present here. And so in our submission, it was a very sensible decision of this court to hear the Crown Act of State issues before giving judgment in the Belhage case.
Good to hear that. Thank you.
The commonality, the symmetry, arises in the following respects. Both start from the position that the case law and the commentaries relating to the doctrines share one common thread. They are profoundly muddled and confused. Both argue that it is time to step aside from that confusion and work on the basis of principle to identify what the underlying rationales are and hence what the permissible justifications for the doctrines should be. Both argue that critical to identifying a principled approach is the location of the doctrines in a modern constitutional setting. Both argue that a further key to ensuring a principled approach is the separation of questions of justiciability of the acts which take place on the international plane from the circumstances in which the courts will refuse to exercise its jurisdiction in respect of such acts. And both argue that the justiciability of such acts falls to be determined according to a unitary conception of justiciability. That is a conception that is of general application to any case that comes before this court. It's a conception firmly planted in a modern constitutional framework. And in so arguing, both rely entirely on the analysis of the Supreme Court in Shergill, where that unitary rule of justiciability of general application has been so recently and helpfully framed. And both treat residual questions about whether the courts should adjudicate in relation to foreign states or the executive in their international acts as issues to be determined in the field of the conflict of laws. So there is a very clear symmetry and coherence of approach.
So just making sure that I've understood it, you want to separate that sort of analysis, which you say is pure conflict of laws, is it, from justiciability, and the issue of justiciability is one which must be applied across the board. And in what sense are you using the word justiciability? In the absence of manageable standards sense?
In the sense that, by reference to a modern conception of the separation of powers, those matters that are non-justiciable are those matters that sit outside the sphere of judicial competence. So,
because there are no judicial or manageable
because
standards.
there are no judicial manageable standards.
Not because of any separation of powers conceptions. Or
It
are they
is a separation of powers.
It is a separation.
It's precisely a separation of powers issue. This is beyond the competence of the courts. It is within the institutional competence. In this instance, in its application here, it is within the institutional competence of the executive.
I think the difference between justiciable because of no standards and the separation of powers are two different concepts. One is the nature of the issue is such that it's not for the judiciary, it's simply for the executive. And the other is because the issue is one that raises the issue is one that raises points that judges can't determine. And the latter is a little difficult because in the end, judges should be able to determine almost anything if they have to.
Some things they simply can't determine.
Well, no,
But
some they can't because of the separation of powers, or because they're inherently incapable of being determined.
Well, there may be some that are inherently incapable of being determined, but there are ones that are incapable of being determined inherently because of the separation of powers. They fall within the institutional competence of the executive.
And that's the latter one where
That is a separation of powers.
Yeah, and it's the latter one we're primarily looking at here.
Yes, well, when we look at Shergill, we will see the way in which this court has identified the distinctions between that which is non-justiciable and the courts can never look at. Even if there is a domestic foothold, the courts can never go there and entertain a case. And those cases where, unless there is a domestic foothold, they will not go there. And those are distinct conceptions of justiciability. So the courts are competent to, but only where there is a domestic foothold. So what both approaches to Foreign Act of State and Crown Act of State do, the approach taken by on behalf of Mr. Belhage and the approach that we take, is that they seek to separate and look at in an analytically separate way situations where the court will not adjudicate because the matter is non-justiciable, in the sense that it can never adjudicate, and not non-justiciable in the sense that it won't adjudicate unless there's a domestic foothold, from cases where the court is standing back and saying, while we are practically competent and capable, institutionally competent to look at this, we will not do so because of one reason or another. And the approach that we take seeks to separate out those two different analytical frameworks. And we submit that that is necessary because unless and until you've done that, it's impossible to identify what kind of a creature the defence or rule of non-justiciability that the appellants put forward is. And unless you can identify what kind of a creature it is, you can't subject it to the necessary testing for whether or not that rule is justifiable or not.
So when we listen to the rest of your submissions today, Ms. Kaufmann, and when we hear the word non-justiciable, are you talking about situation number 1, situation number 2 as well?
I am talking about, and we'll come to it in a second. We'll look at Shergill, and I know that the court is familiar with Shergill, but we're looking at it in a different context now in relation to its application to a different doctrine. So I would like to go through those passages again, and then it will become clear, having done so, exactly what I'm talking about.
Very well.
And when I talk about non-justiciable, I am talking about Category 1 non-justiciability, not circumstances where the court is capable of adjudicating,
I see.
but only where there is a domestic foothold, which enables it to exercise its jurisdiction.
I mean, one's got to be careful about treating Shergill and Cara as if it's a dictionary or the answer to the present case or binding. We absolutely did not, in Shergill and Cara, address in argument or, I think, in our minds, all the implications of a case like the present.
No,
the
and
Act of State is in the statement of principle. Act of State is at the outset put to one side as concerned with other matters.
Yes, we'll come to it. I understand that, but what the court did do is it looked at the rule of justiciability by looking at Butts, which was a case which is precisely about Act of State and the non-justiciability concept of it, and that was distinguished from another element of Act of State, which was the bit that was put aside at the beginning.
We're dealing with circumstances in which an issue can be said to be beyond the judicial competence, and simply making the point of how narrow that is. But we're not really concerned in this case with judicial competence. The judiciary is always competent to determine what the foreign law of tort is. The question is whether it has any application.
Yes, But in looking, in our submissions, it's important to look at the kinds of issues that the court has found itself in the last 40 years competent to look at in the field of foreign relations in order to have a clear conception of how the rule of justiciability works, and then to address, within that framework, how to situate the defence and
Yes.
where it falls to be assessed.
Yes, I think Shara was not, of course, a case involving anything of the sort. It was just the Court of Appeal had, in our view, misdirected itself completely about the law of non-justiciability, and we were simply setting out the general approach, consideration of when non-justiciability arises. But I think one must be careful of relying on it on specific, detailed word-for-word analysis in relation to a case like this, which clearly wasn't in the court's mind. But by all means, anyway, let's see where we go.
If I can take the court to it, and we'll work
Yes, of
through
course.
it, and then we will advance
Okay.
as to why we submit it. So it
Yep.
is a very valuable set of principles and conceptions of what the court does, doesn't do, isn't capable of doing. So we go to, it's in volume 1.
It's 9269, isn't it, really?
Yeah. So, tab 7, and if the court will start at 37,
All right.
so that's 9267. So it's dealing with the heading, just non-justiciability generally, and the first case to which reference is made is by reference to the judgment of Lord Justice Mummery, the Buttes gas case, and that is then considered by this court in paragraph 38, and then at 39 it is recorded that Lord Justice Mummery regarded this statement as authority for the proposition that in the absence of objective juridical standards by which to decide an issue, a court must regard it as non-justiciable. And then we have the analysis set out in paragraph 40 of what the court meant in Buttes gas when it talked about non-justiciability. So the point to be made here is the obvious point that while this case was of course not concerned with Foreign Act of State doctrine or Crown Act of State doctrine, it was looking at non-justiciability generally, and it treated cases arising in respect of the international acts of states as being no different in terms of one's understanding of the general principles of non-justiciability from the circumstances of the case that were before the court.
And we get the point about the proper province of the executive between G and H, yeah.
I'm sorry, my lord.
We get the point about the proper province of the executive between
Yes.
G and H, yeah.
So the reason the reason given here for why the acts in question in Buttes were non-justiciable was because they were political. And they trespassed on the proper province of the executive as the organ of state charged with the conduct of foreign relations. The lack of judicial and manageable standards was the other reason why it was political. And effectively, that's describing a situation in which those acts are simply not bounded by law. They are pure exercises of political power, and that harbours back to the language of the Camachi case and the concept of non-justiciability that was being developed.
These were foreign act of state. The foreign acts of state.
These are foreign acts of state, yes, but it would
I
be...
mean, it's a pretty broad conception of political, because in the Camachi case, no doubt you could have gone to a local Camachi court, which would have said, there's nothing in our law which allows anyone to invade with armed men and take over the palace. So, in one view, it was just an obvious breach of local law, but it was described as political in the same sense that the European Court used the phrase in Markovich. It was a matter of high international policy, an acte de gouvernement, which it operates, however you describe it, on a different sphere to ordinary acts which you expect to be judged by domestic law.
But that's the critical point, is one can come along and one could say, this breached all my rights. But the answer to it is, it didn't breach your rights because this was not an act that was subject to municipal law at all. It was an act of sovereign power, however narrow that conception now is. It was an act which, so far as the justiciability of that act is concerned, so far as the assertion of our judicial competence is concerned, it wasn't subject to law, domestic municipal law.
Yes, and I mean, I think
And
ultimately the question is what is properly regarded as subject to domestic law, and when do acts achieve that quality which takes them out of jurisdiction, effectively.
Absolutely. That is the critical question, and that is something in respect of which the court's conception has changed enormously over time. So when we look back to the situation 150 years ago, one way of reading Burren and Denman, and we'll come to it, is to say that any act of the executive abroad is not done under colour of municipal law. It is an exercise of sovereign power that is not governed by law on the municipal plane. Now, that is not the case anymore. We have narrowed the conception of those acts in respect of which the executive does not have to account to the law massively over the last 150 years, and hugely accelerated that limitation in the last 40 or 50 years with the development of judicial review, so that we find a situation in which what the court goes on to say in paragraph 42 is this. So the first category comprises cases where the issue in question is beyond the constitutional competence assigned by the courts under our conception of the separation of powers. Cases in this category are rare, and rightly so, for they may result in a denial of justice which could only be exceptionally justified at common law under the Human Rights Act. The paradigm cases of non-justiciability are certain transactions of foreign states and proceedings in Parliament. The law does not reach into these areas. The first is based in part on the constitutional limits of the court's competence against the executive in matters directly affecting the kingdom's relations with foreign states. So far as it was based on the separation of powers, Butte's Gas is the leading case in this category. And then this proviso, although the boundaries of the category of transactions of states which will engage the doctrine now are a great deal less clear today than they seemed to be 40 years ago. And we can see why they're a great deal less clear today than they were 40 years ago when we look at paragraph 43. Because in paragraph 43, the court looks at a second category of non-justiciable cases, which is quite different. Now, this category covers many cases concerning the international transactions of the United Kingdom, or foreign states for that matter, where the court will not exercise justiciability directly in respect of that international transaction, because there's no domestic foothold, it's going on up there on the international plane. But if there is a domestic foothold, it will adjudicate in respect of that. It has the competence to look at that international act. And they are two very, very distinct categories. And category 2, 43, has been filled over the last 40 years by acts which formerly would have fallen within the conception of category 1. Formerly, our courts would have said, pre-CCSU, of a huge number of transactions of the executive, they are not subject to municipal law. They are prerogative acts, and we do not adjudicate upon them. CCSU marked a narrowing of that, and post-CCSU, we have a myriad of cases where the courts have narrowed further that area of category 1 non-justiciability. And in our submission, that conception of the two ways in which non-justiciability works is an incredibly valuable analytic tool which enables, when we're looking at this defence, it enables the court to proceed in a way that properly understands the nature and quality of the defence that is under consideration. It is not, and we are not concerned with, a Category 1 situation.
Why not? I mean, you said yourself that it's a bit like an hourglass, so the question is how far the hourglass has emptied. If items which were in Category 1 are moving to Category 2, then it's a judgmental question. I mean, just taking Butte's gas, if you can't adjudicate upon whether the two Gulf states are right or wrong in their warring activities, why is it any more logical that you should adjudicate upon whether the United Kingdom, if it happens to be warring with one of the Gulf states, is right or wrong? It seems to me that there's plenty of room for argument as to how wide Category 1 is.
Absolutely, and I mean, there really is. But what we can say categorically, my lord, is whether the question of the legality of a war falls within Category 1, what we can categorically state is justifications or the fact of detention of individuals, the fact of ill treatment of individuals who are...
We're not concerned with ill treatment, are we? That's out of this. It's accepted that if the British government beat up a detainee, nothing could justify that or make that the government immune. I think I'm right.
It's accepted if they were tortured. There are all manner and forms of ill treatment short of torture. It's accepted if they were tortured.
I think the acceptance is wider than that. I think the point was made that the executive has never sought to authorise, let alone ratify, acts of maltreatment.
Well, whether he's
But it is part of its policy to detain people.
Whether he sought to authorise it or ratify it, we are talking here of questions of principle. Would those acts be justiciable or not justiciable? And the point I'm making is whatever policy the Secretary of State may or may not adopt, they are acts which are justiciable by our courts should a claim be brought to these courts in respect of that form of ill treatment. That's the critical question we have to focus on here. And why do I say that even if the question of whether a declaration of war remains non-justiciable or is undecided and could remain non-justiciable, it is nonetheless the case that the acts in question in these proceedings and the application of force or the use of detention techniques in the context of military operations is justiciable. Well, I say that because there are cases in which the matters have been looked at by the court. Rahmatullah and detention of an internee. That's precisely such a case. And our courts didn't say, sorry, this is beyond our constitutional competence because it is an aspect of a declaration of war. They looked at the matter. It's justiciable through the Human Rights Act. The courts are in these very cases, look at the legality of Mr. Rahmatullah's detention, the Iraqi civilian's detention, Mr. Mohammed's detention. In fact, they've looked at Mr. Mohammed's, the legality of that detention in relation to Mr. Mohammed already, under the Human Rights Act. Were it the case that there was a form of ill treatment which the government did seek to bring within the umbrella of Crown Act of State, that would also be justiciable under Article 3 of the Human Rights Act. So these matters are ones that fall clearly within Category 2. If there is a domestic foothold, the courts will look at it. And so we have to look at the defence within the framework of there being no bar upon the courts looking at and judging the legality of these acts, albeit according to a different body of law, be that the law of habeas corpus, be that a Human Rights Act. And another case, which is worth looking at as well, it's, I'm afraid it's not in the bundle of authorities.
Is it one of the ones that's been put on our desk?
One of the ones that were it's handed up this morning.
Which is that?
It's under a yellow, it's got a yellow tab. So
I see, it's Hadi Ali Hussein.
That's exactly it.
Thank you. Where do you want us to look?
Now, this is a case in which it's a judicial review, and it was a judicial review. If the court looks at paragraphs 1 and 3, the nature of the challenge is set out at paragraph 1.
Yeah.
So it's a case where what was being challenged was a policy. Not just the acts done under or in execution of the policy, it was the policy itself, the policy by which the military operations were being conducted or would be conducted anywhere in the world, because it was a policy of general application. The claim was brought by an individual who had actually been detained in Iraq. He hadn't been subject to this policy, and there were questions about his standing.
Yeah.
Despite those questions, the court adjudicated upon the legality of this policy. Now, the policy was being challenged on the basis of its non-compliance with international humanitarian law. So it was a challenge for non-compliance with international law. No problem there in the court adjudicating upon issues of international law in this instance, because the policy itself purported to apply international humanitarian law. So
Ms.
that can be
Kaufman,
seen...
I'm terribly sorry. I'm sure it's my fault. I actually can't locate this particular authority.
I'm sorry about that.
No, I'm sorry.
I think you've got two of them.
I have a copy.
I've been given two of something else, so it may be that there's been an error.
I have a copy here, which I...
Thank you very much indeed. I'm so sorry.
So if the court goes to paragraphs 27 and 28, the nature of the challenge is set out. The explanation is given as to why the challenge is based on international law. And at 29, so it's a conventional judicial review on conventional grounds, challenging the policy by reference to its own terms, whether it does that which it says it should do, and then challenging it on a second conventional public law basis, that is, it gives rise to an unacceptable risk of illegality, which is the principle most recently identified by the Court of Appeal in a case called Tabac. So at 31, the court then explains that this policy is potentially of general application in the field of armed conflict. So that's another instance of how the courts will subject the operations of the military in the field of armed conflict to its adjudicatory processes and to the constraint of law. Clearly, Category 2 cases.
Ms. Kaufman, these cases are all about the limits of the power of the executive in this kind of situation. And the last appeal that we heard in these proceedings is concerned with whether, for example, a power to detain existed. But we're actually not concerned with that in this appeal, are we? What we are concerned with is whether the private law of tort of Afghanistan applies to those who are carrying out the policy of the executive in relation to an armed conflict in Iraq or Afghanistan. And I can't see that that's got anything to do with the decision-making process. The last appeal certainly did, but this appeal is concerned with a completely different question, which is that there are some sovereign acts which by their very nature involve the commission of torts. In practice, trespass to the person or to property. And the real question is whether the law can rationally treat sovereign acts which the state has a power to carry out as being a proper function of the British state and yet at the same time inherently tortious. That's surely the issue.
Yes, and relevant to that question is the extent to which the courts subject those very self-same acts to other legal constraint. So in relation to the Human Rights Act, it's not simply a question in relation to the Human Rights Act as to whether or not there was a power to detain. The question in relation to the Human Rights Act was whether or not detention took place in accordance with the constraints that operate under Article 5 of the Convention.
But why is that an issue in this case? The question is really whether the Afghan law of tort applies to sovereign acts which, if there is a power to carry them out at all, are inherently tortious. But therefore, can you apply the law of tort in the same way as you would to non-sovereign acts?
It's relevant in this case precisely because alongside the tortious claim that is being brought by the claimants, they are bringing claims under the Human Rights Act in respect of the self-same conduct.
But we're not concerned with those claims here. We're concerned with the bog standard law of tort.
Yes, but the fact that the bog standard law of tort is, and the question of whether it applies, falls to be considered in circumstances where its non-application is going to constitute an infringement or an interference with the right of access to the courts that they undoubtedly have.
This is your Article 6 point.
Well, it's not just an Article 6 point. No, it's a Jones and Caney point. This is an immunity from suit, and it has to be justified at common law.
We're in the Markovich territory, but it is a separate limb in the argument. I mean, there is a certain difficulty, isn't there, about accepting that something which is justiciable under the Human Rights Act is necessarily justiciable under the common law. They're different schemes, and although the common law develops, it's not necessarily the same. The classic example, of course, is the question in relation to police liability, which we decided where the human rights claim was able to go ahead, but the common law claim can't. So I don't think you can automatically extrapolate from one to the other.
No, can I make it clear that our argument is absolutely not that because there is now a justiciable Human Rights Act claim, the common law has to be developed to allow a tortious claim. It's not the sort of Michael arguments, the Van Colley arguments at all. It is that the fact that the courts impose legal constraints of the kind that they do in habeas corpus proceedings, in relation to judicial review, in Human Rights Act claims, has a bearing upon whether or not it is justifiable to shut out tortious claims. They have a bearing when one looks at the justifications that are being offered by the defendant and put forward by the appellants for such an immunity.
Yes, obviously we have to decide the position relating to the human rights claims in separate proceedings, but just focusing on this point, review of policy, there is a difference, isn't there, of substance between reviewing a domestic policy, which is an internal matter, a matter of internal good order that the policy should be appropriate, and subjecting the present types of act to a foreign law.
In my submission, no, in substance there isn't, because the policy is a policy whose application is exclusively to take place in the field of detention of internees abroad. That is the nature of the policy. And so if you can review the legality of that policy that dictates how the individual detainee is to be treated, if one can review that policy, why can one not subject to a further legal review or constraint the way in which the individual is treated under that policy? So, for example, if that policy advocated some form of ill treatment, which would unquestionably be reviewable by the courts, why should its application to an individual who suffered ill treatment as a consequence of its application be free from legal constraint?
Can I ask a probably rather naive question about Hyder Ali Hussein, Ms. Kaufman? Of course, it's, from a brief reading, it doesn't look as if Act of State was mentioned at all. Wasn't in question, was it?
No, it wasn't in question.
Oh, but if we look at paragraph 13, it's quite a long paragraph, but the bit you need is in bold, headed the standards. It looks, correct me if I'm wrong, as if the UK had announced a policy declaring in terms that it set out to comply with Common Article 3 of the Geneva Convention. Is that right?
Yes.
And so the court was being asked to say whether it had actually complied.
Yes.
Or not.
Yes.
And so what the case shows is that investigating that question doesn't run up against a no-tools problem.
No.
Does it show anything else?
What it shows is that where there is a domestic foothold, the court will look at a policy which is to be applied in the context of military operations abroad.
Well, I dare say. But that's because we've declared that we're going to do it in accordance with a particular standard, and the question can be asked whether we have or not.
Yes, and so had that policy, put away the particular standard, had that policy made provision for some form of ill treatment, torture, for example, putting aside that the Secretary of State has disavowed that and putting aside at the moment that whatever this immunity is, it doesn't apply to torture. Yeah. But let's imagine we are just looking at the justiciability of a policy that makes provision.
It's examinable, that's clear.
It's clearly...
It's not a no-tools point. So if you're right that the limits, the act of state is limited to no tools, you're home and dry.
Our argument is not that act of state is limited to no tools. Our argument is that the justiciability principle is limited to no tools. Yes. One then has to ask oneself, once we've put aside the question of justiciability, what is left for act of state? What is the basis for the immunity? For the court stepping back and saying, we are not going to adjudicate on these tortious claims. The fact that the court is prepared to adjudicate on the treatment of individuals in respect of a policy that is applicable in relation to military operations has a bearing upon the justifications that can be offered for a rule of immunity. That's the point that we are making.
Got it. Thank you very much.
We need to be clear that the courts will look at these things, they will subject them to clear constraint. There are two other cases which one is in the bundle, and it's in 6471138. I'm not going to take the court to them now because I'm conscious of the time, but there are two that I'd ask the court to look at, perhaps in your own time. So that's the Youssef case, tab 6, 4711038, and then the case of Ahmed, which is another case that I handed up
110
this morning. It's the pink one. It's very big, very long judgment. Both cases of the Supreme Court. Now, they both arise in the context of the designations by the UN Security Council under the 1267 list of an individual as a threat, a terrorist threat, who is thereby required by the state within which he resides to have his assets frozen. So it is a case in which there is a UNSCR which creates an obligation upon states to freeze the assets of individuals who are identified and named by the Security Council itself. And again, so we're dealing with a case in which the decision to subject the individual to the listing process and the obligation thereby to have his assets frozen takes place entirely on the international plane within the body of the United Nations. But nonetheless, even that fact does not stop the courts from adjudicating upon the legality of that individual's designation. That was the case in Ahmed, through Section 1 of the United Nations Act 1946, which is the mechanism by which effect is given to United Nations Security Council obligations. And the Youssef case was another case where the court strived to find a means by which they could adjudicate upon what had happened to this individual. So in the Youssef case, the court found that whereas the actual designation of Mr. Youssef by the Security Council was not reviewable on a freestanding basis because it was an international act, nonetheless, the exercise of the Secretary of State's prerogative powers in the field of foreign relations to put a hold on his designation initially was reviewable. That pure exercise of prerogative power in respect of this clear international act.
Which paragraph is that in this rather
So
lengthy?
the relevant paragraphs in Youssef are 22 to 26.
Sorry, Youssef is...
That's at 647-11038.
A647.
Yeah,
11038.
yeah, and it's at 11049, paragraphs 22 to 26. And it's a judgment given by Lord Carnworth.
Which bundle is this?
A647.
Thank you.
22.
And the key passages in the Ahmed case,
What were the paragraphs in Youssef?
so 22 to 26.
Thank you.
And the key passages in the Ahmed case are so 18 and 19, which give the history of the relevant UN SCRs.
Sorry, which paragraph of Youssef are you on?
Of Youssef, 22 to 26.
I find it difficult to see why Ahmed has anything to do with this case, although there's an awful lot of paper, so one would hope it does. The issue in Ahmed was whether the government was entitled by subordinate legislation to give effect to, under the United Nations Act, to give effect to the UN asset freezing scheme. That was a question of domestic varies. It didn't involve examination of the legality or anything of the international scheme. It just involved saying this type of scheme is beyond the scope of Section 1 of the United Nations Act.
No, yes, but the reason it was beyond the scope of Section 1 of the United Nations Act is because the court read Section 1 of the United Nations Act as requiring an opportunity for the individual to be able to challenge the designation in court. So to challenge a decision of the United Nations Security Council.
Well, we actually read it shortly as not contemplating subordinate legislation which would affect the effective liberty of the individual. A freezing order being equated, in Lord Hope's words, with a form of deprivation of liberty. I thought it was that simple point. But
yes, but the point being, the court did not stand back and look at the fact that the United Kingdom was acting in accordance with obligations imposed on it at an international level and say, we are going to interpret Section 1 in a way that gives effect to that obligation. It nonetheless considered itself, it nonetheless interpreted Section 1 as not entitling the executive through the Ordering Council to ride roughshod all over those fundamental rights of the individual.
Where were these two chaps, Youssef and Ahmed?
They were here.
They were here.
Here, weren't they?
They were here.
Thought they were.
Yes.
yes, about 1 million.
Anyway, give us the paragraph numbers, Ms. Kaufman.
So the relevant paragraph numbers are, in relation to Ahmed, Lord Hope at 81 to 82, Lord Phillips at 154 to 155, Lord Roger and Lady Hale at 185 to 186 and 188, and Lord Mance at 239, 240 to 241, and then 248 to 249. And then Lord Mance made the observation in paragraph 249 that had the UNSCR made a provision, for example, for the internment of that individual, there would unquestionably be a power that would be justiciable in relation to its execution. Now, it's clear that that was in a situation where it was the internment would take place in the United Kingdom. But what it demonstrates is that even where conduct is mandated under a UNSCR, the courts will not stand back and say, there is nothing to be done about this situation. We must give effect to that mandate. We must interpret.
The executive can't, by concluding a treaty, give itself powers within England that it wouldn't otherwise have. Yes?
Yes, but that can be relevant to the way in which the courts approach Section 1, because the power that it has is given by Section 1, and Section 1 entitles it to, or the object of Section 1 is for the executive to be able to pass orders in council to give effect to that mandate. Right. So it would have been open to the court, and that's the path that Lord Brown recommended, to say the whole purpose of this legislation is to enable Security Council resolutions to be passed into law. But it didn't do that. So, can I then just move on to look at the Al Jeddah case very, very briefly? In Al Jeddah, in both the High Court and the Court of Appeal, both those cases were decided by reference to justiciability and not by reference to the defence, and both held that because the internment was done pursuant to a UNSCR mandate, the matters were non-justiciable. And in our submission, that analysis does not sit with the analysis of the House of Law, of the Supreme Court in Shergill, and does not sit with what we can see that the courts do, even in relation to UNSCRs. So far as Nissan is concerned, I'm not going to go back to Nissan. Nissan was, it seems, a case that was concerned to look at the rule of justiciability insofar as it applies to the foreign acts of the Crown. But your Lordships have, and my lady have clearly read it in great detail, found it difficult to identify a clear ratio. And in any event, in our submission, the analysis in Shergill of how justiciability falls to be analysed has overtaken that analysis, and also the developments in our courts over the last 40 years has also overtaken the way in which the court, the House of Lords, analysed matters in Shergill. So, in our submission, the Court of Appeal was right to endorse the Shergill approach. It was right to conclude that the acts which are the subject of the tortious claims are plainly justiciable, and that's for the reasons which the court itself has already referred to. Through Peeler, there is a foreign tort law which our courts are plainly competent to apply, and therefore we submit it is quite wrong for the defendant or the appellants to maintain the confusion by submitting that it doesn't matter whether this rule is characterised as a rule of justiciability or as a defence. It does matter. It is not a rule of justiciability. It is a totally different creature. It's not beyond the constitutional competence of the court. It is focused exclusively on the application of tort law, and it creates an immunity from suit in respect of claims in tort. And that is clear from this. The focus has been on applying foreign law. But Peeler provides choice of laws, and it would be entirely possible, if it was considered inappropriate to apply foreign law, to apply English law. But that is not the choice that this rule gives. Its application means that the claim cannot be entertained by the court at all. It doesn't mean there's a reason not to subject the Crown to the foreign municipal law, will apply domestic law instead. It is tort law shall not be applied in any shape or form. So, can I then turn to the defence and the question of whether or not the defence ever existed, whether or not there was ever a defence created in Burren and Denman. And in one sense, because we accept that it is possible for this court to develop a rule of abstention, arguments about whether or not a defence ever existed are, in one sense, neither here nor there, but in our submission they're important because what the defendant seeks to do, what the appellants seek to do, is to say, well, there was this defence, and what the courts must do is to preserve it and develop it in an incremental way. And in our submission, our primary submission is that's the wrong approach. Our primary submission is actually the defence must be justified according to modern conditions as necessary and proportionate to a legitimate aim. But if we're right that there is and never was a defence, or if there was a defence it hasn't survived, then we don't even meet that problem about the incremental development according to the common law method of this defence. So can I do a swift review through some of these old authorities? We'll start with Burren and Denman, and I know the court has read this judgment in some detail, so I'm not going to go to lengthy passages from it. But the starting point in relation to this case was that at the time, I know that your lordships and my lady are aware of this, but it's important to have it in mind, at the time the court could only sue Crown servants or agents in respect of anything done on behalf of the Crown. So it's in that context of always bringing the claim against the Crown servant or agent that Burren and Denman was decided. So if the act being done under the touchstone, under the authority of the Crown was the touchstone for bringing the claim against the servant or agent, there would have been no reason for the courts ever to embark on an inquiry, such as they did in Camachi, about whether the act was in the nature of an act of state. Simply wouldn't have made sense. And in our submission, there are three ways that we can read Burren and Denman. So we looked at the treaty, we saw the terms of the treaty, and we saw yesterday that all the acts that took place, or not all the acts that took place, were covered by the terms of that treaty. Now, we know from the case of Camachi, decided 10 years later, that entering a treaty and, by implication, carrying out the acts pursuant to it is, or was considered to be, a sovereign act of the kind that is captured by the doctrine of act of state. So one way to look at this case is that the acts took place in the context of giving effect to a treaty, and that is what gave those acts their character as an act of state. So the fact that it wasn't actually done pursuant to the precise terms of the treaty does not mean it wasn't an act of state because it was done in the course of giving effect to that treaty.
This is the Spanish treaty.
No, this is the treaty. So the Spanish
It's the treaty with the king.
It's the treaty with the king. And that's the treaty, that, or rather, that's the treaty that allowed the Captain Denman, to take the slaves and free them. But what it didn't allow him to do was then to destroy all the chattels within the barracoons.
Surely the treaty didn't even allow him to take the slaves and free them. That was something that the king undertook to do. And the decision appears to have proceeded on the basis that because Captain Denman exceeded the powers conferred by the treaty, he needed to have his act ratified, which it was.
In my submission, it's difficult to read this as a decision based upon him having exceeded the treaty in all those respects. If one looks at, as we did yesterday, the description of what he did, it is written in the court reporter's note that what he did was in execution of the treaty.
I'm not sure.
It's a very sophisticated analysis to say that the court would have had well in mind that he hadn't acted in accordance with the treaty and therefore all of his acts needed to be ratified. A much more obvious way to look at this case is there was a treaty. Whether or not Captain Denman was allowed under that treaty to free the slaves, the whole object of the treaty was to allow the slaves to be freed, and Captain Denman did that, no doubt, on behalf of the king. But what was done was within the terms of the treaty, and insofar as it wasn't done in the terms of the treaty, it was done in the course of giving effect to those treaty obligations.
The difficulty about that is that that particular treaty with the king isn't referred to, is it, in the summing up? It's the treaty with the Spanish crown, which is held not to have been complied with, and therefore ratification, as my lord says, is necessary. But I don't see that the cloak of the treaty with the local king is even referred to. Am I wrong?
Just bear with me one moment, my lord. Yes, it's at paragraph 9013.
Sorry, in
9013, immediately below the provisions of the treaty.
Yes, correct.
On the 23rd, so just undersigned.
This is part of the reporter's summary of the
Yes.
facts.
Yes. I was just looking
It
at the
is.
summing up. Yes.
It is. It's part of what was reported, and it's reported as the defendant in executing the treaty commenced burning the plaintiff's barracoons. So that was the understanding of the court reporter in relation to that. And then we have at paragraph 9018, page 9018, page 459,
Yes.
the second paragraph, the principal question is whether the conduct of the defendant in carrying away the slaves and committing the other alleged trespasses can be justified as an act of state done under the authority of the Crown. And no distinction is drawn between the acts that are done under the treaty and the acts that are done outside the treaty, but in the course of giving it effect. And in my submission, that can only be explained on the basis that a distinction wasn't drawn between those acts which were giving effect to the treaty and those acts which were done in the course of executing the treaty.
Well, I mean, it's very difficult to believe that this case is going to turn on the exact terms of a treaty concluded with an African prince in 1842. But on the face of it, if Captain Denman was acting in execution of the treaty, he was, as you have yourself put it, acting on behalf of King Siaka, who was the person who undertook to destroy the factories, and the question at issue was what was the consequence of his having acted on behalf of the Crown rather than King Siaka.
But the point about entering into a treaty and giving effect to it is that once a treaty is entered into under the analysis in Kamachi, the court simply doesn't inquire into the nature of the acts, whether they were authorised or not under the treaty. Those acts become non-justiciable because they are exercises of sovereign power that do not take place on the municipal plane. And so one can either analyse this as what the court said here is the treaty is a sovereign act, we therefore don't inquire into what took place, any of it, or it was a sovereign act, and insofar as the treaty authorised the taking of the slaves but didn't authorise the destruction of the chattels, what is clear is, from the fact that the destruction of those chattels took place in the context of the treaty, which itself is an exercise of sovereign power, those acts too must have been an exercise of sovereign power, not purporting to be done under colour of municipal law, see Kamachi, and therefore they are also acts of state within the non-justiciability conception. A third way of looking at it is to say, actually, what Beran and Denman did was to massively enlarge the non-justiciability of the acts of the Crown on the international plane, to the point where any act that was authorised by the Crown on the international plane is non-justiciable. Any act of the executive, authorised or subsequently ratified, is non-justiciable. But whichever way one looks at it, this is a case which is decided upon the basis of whether or not the acts are justiciable, in the sense that they are acts which are done and answerable to municipal law.
I mean, which parts of Baron Park's judgment do you rely upon as basing his direction upon non-justiciability?
I rely upon what he says as to the effects of the ratification, which are at, we've been at 9018, and if we then look down to the passage where, having set out the principal question, and he said it's not contended there's any previous authority, he then looks at the impact of ratification and compares and contrasts what happens where an act of a private individual is ratified, and the consequence of ratifying the act of a private individual is that the principal becomes liable. By contrast, where you ratify, or the Crown ratifies an act, it ceases to be the act of the Crown servant and becomes an act of the Crown, which is not subject to the jurisdiction of the courts, and it ceases to be subject to the jurisdiction of the courts.
Well, I mean, that analysis established that this, in relevant respects, was an act of the Crown. I don't see that it establishes that Baron Park was directing the jury that it wasn't justiciable. He was simply assuming that, for whatever reason, there was no liability if it was an act of the Crown.
But the problem is that an act of the Crown, ordinarily, a Crown servant is sued in respect of acts that he is authorised by the Crown to undertake.
Yes.
So here, the consequence of him being authorised by the Crown is that he cannot be sued. That is the reverse of what ordinarily takes place.
Well, that I quite see as the result, but what I don't understand is where you get the idea that, having concluded that this was an act of the Crown, Baron Park thought that it was non-justiciable as opposed to an act which simply could not give rise to liability.
For the very, very simple reason that there has to be a distinction drawn between the ordinary situation where, if your act is authorised as a Crown servant, you can be sued in respect of that act, even though it is a Crown Act, and the situation here where the fact that it's authorised suddenly means you can't be sued at all. Now, that means there must be something in the nature of the act that means it has a different result. Ordinarily, you can be sued for an authorised act. Here, you can't.
Yeah, but it doesn't tell you what the nature of the different result is. The nature of the different result may be that you have a defence, or it may be expressed in terms of non-justiciability.
Or it may be expressed in terms of lack of jurisdiction.
Or lack of jurisdiction. And I'm not sure they had to go into that, but I mean, insofar as the language is used, what is said is that it's no longer actionable, or that the defendant is irresponsible, if you look at the opposite page near the end. And that's the very brief reasoning.
Yes, and in our submission, such brief reasoning from which it is impossible to say that Baron Park was here, in his summing up to the jury, identifying a huge rule of immunity in respect of all acts of the Crown abroad, where there is a simple ratification of that act, as opposed to the much more obvious inference, which is that what he was saying was these acts are in the nature of acts of state, and the consequence of ratification is simply that the acts then become acts which do not take place in the sphere of municipal law. And
They can only be acts of state so far as they are acts of the Crown.
I'm sorry?
They can only be acts of state so far as they are acts of the Crown.
Well, acts of state have a very specific, in terms of the non-justiciability limit.
If this had been a private frolic of Captain Denman's, unauthorised and unratified, it couldn't have been an act of state because it wasn't attributable to the Crown.
No, but it doesn't follow that every act of Captain Denman then becomes an act of state.
No, I mean, the strength of your case is that if one treats this as something which the Crown either authorised or ratified, and they're the same ultimately, it involved, without authority, it appears, going into another country and destroying a good deal of property, which is pretty high-handed and could be regarded as a sovereign act, by force, of course, by sending your military forces in. So it's open to you to say, and I think you are saying, it should be narrowly confined to what a certain type of really sovereign acts.
Yes, and so all that is doing...
The context of the treaty is what you're saying, isn't it?
In the
saying
context
it should be confined to acts in the context of the treaty, and actually from your point of view, it doesn't matter whether it's the treaty with Spain or the treaty with the King, it's a treaty. And it's that context which makes a difference, you say.
Yes,
and
because
as I understand it, you say alternatively, it's so sweeping that either he can't have meant it, or if he did mean it, he was wrong.
It's a little difficult to see how it can be if it was either under the treaty or it wasn't. The executive can't extend the treaty by its own executive decision, which is the effect of what you're saying, isn't it?
No, because the executive can't.
No.
But the touchstone in the Camachi cases was what is done under colour of municipal law, and they judge it by reference to whether the executive intended to be bound by municipal law. That's what happens in Camachi. They look at what they did, and we can go on and look at it.
I see. Yeah.
I mean, this was 150 years ago in a very, very different age. During
If
the
the
height of
executive thinks it's being done under a treaty, it is done under a treaty.
I'm sorry?
If the executive thinks it's being done under a treaty, then the judiciary will treat it as being done
Or not even that. Even if the executive steps beyond the bounds of the treaty, if it is not intending its acts to be bound by municipal law, if they are simply an exercise of sovereign power, according to the analysis applicable at the time, then that is an exercise of sovereign power. It's very much a rule that allows the executive free rein, as it were, to decide what their acts are and what their acts aren't, as long as they fall within a specific framework. So here, treaty, or an act of aggression, which could be an act of war, or annexation. And we can see that from Camachi. So if we look at the Camachi case, that's at 290. Sorry, that's at tab 2. I'm sorry. 9020, yeah. And yesterday, Mr. Eadie conceded that most of this case focuses upon the rule of justiciability. If we look at the head note, we can see held under the holding. So this was a case in which you can see from that, if you just quickly read the head note, the Raja dies and effectively all his property, both private and property of the Raj, is taken by the East India Company. And the holding at the bottom of that first major paragraph just under Semble held that as the seizure was made by the British government acting as a sovereign power through its delegate, the East India Company, it was an act of state to inquire into the propriety of which a municipal court has no jurisdiction. And then at the bottom of the holding, an act done by an agent of the government, though in excess of his authority, being ratified and adopted by the government, held to be equivalent of previous authority. So all that the ratification does in this case is extend or in relation to an act that is the character of an act of state, it converts it into an act of state because the authorisation, the ratification, makes it an act of the Crown. And we can see that the court analyses Lord Kingsdown's judgment of the Privy Council. This is 10 years after the Burren and Denman case. At 9039, Lord Kingsdown, at 9040, starts to look at the character. So this is the third paragraph down. The next question is, what is the real character of the act done in this case? Was it a seizure by arbitrary power on behalf of the Crown of Great Britain of the dominions and property of a neighbouring state, an act not affecting to justify itself on grounds of municipal law, or was it, in whole or in part, a possession taken by the Crown under colour of legal title of the property of the late Raja of Tanjore in trust for those who by law might be entitled? If it were the latter, the defence set up, of course, has no foundation. And they call it the defence, but they are clearly describing a rule of non-justiciability. And they then go on to look at what property the East India Company intended to take, and found 9041 at the top, that it manifested an intention to take all the property. And then it concludes that these were acts not purporting to justify themselves on the basis of municipal law, but they were exercises of sovereign power. And we then come at page 9043.
Because it's between two sovereign powers.
Page 9043, part way down the second paragraph, a line dealing with a letter referred to of the 8th of September. And this is the letter of ratification. How is it possible in the face of this declaration to hold that it was the intention of the government to recognise the right of inheritance of the respondent and to exclude from seizure and to subject to the process of law any portion of the property of the deceased sovereign? If there had been any doubt upon the original intention of the government, it has clearly ratified and adopted the acts of this agent, which, according to the principle of the decision in Burren and Denman, is equivalent to previous authority. That's all that Burren and Denman does, is it treats subsequent ratification as equivalent to previous authority. That is, it makes the act, which is, from the analysis that has gone before, in the nature of an act of state, not an act purporting to be done in accordance with municipal law.
The writer of the headnote seems to begin on page 9020 by assuming that this is important factor is that it's transactions of independent foreign states, sovereign states, between each other. In other words, it isn't an act by a sovereign state against an individual. It's against an act by a sovereign state against another sovereign state.
Well, that's what it was concerned with here. It's not
Yes.
then saying that is what it is limited to, but certainly that is what arose in the context of this particular case.
And Bjorn and Denman is simply cited on the ratification point, not on the act of state point.
No, precisely. But if Buren and Denman had been a case in which what had been decided was that any act of a Crown servant perpetrated abroad, once ratified, is an act of state, then it would have been wholly unnecessary for the Privy Council to have embarked upon an inquiry as to whether or not, so far as the rule of justiciability was concerned, the act in question was in the nature of an act of state. The whole exercise would have been completely unnecessary because the mere ratification of the act, which it found had taken place, would in and of itself have transformed it into an act which could not be inquired into in the municipal court. But it didn't do that. It went through the whole inquiry as to what the nature of the act was, and only after that inquiry did it ask whether or not the act had been ratified. And that was the significance it took from Burren and Denman, was that all that ratification does is it makes it equivalent to prior command. But you have to establish first whether the act is in the nature of an act of state, because if it isn't, then that ratification is not going to transform it into an act of state. That's the clear implication of the approach of the Privy Council.
Yes, I mean, but in this case, the distinction seems to have been between an act of taking over property under law with a view to administer it in accordance with the ordinary law, and an act taking it over regardless of law with a view to doing what you want with it, regardless of individual rights, including the Queen Dowager's rights. So I suppose that's a slightly different point from, but I mean, it certainly means you look at the nature of the act from that point of view.
Well, what it is it's an approach which asks the question, what are acts of state?
Yeah.
And that is defined by reference to whether or not the act is one performed under municipal law or is an exercise of sovereign power, pure power, not subjecting itself to municipal law. If it is of that kind, in the context here of the relations between states, then it is an act of state. And if that act is performed by a Crown servant, so long as the Crown ratifies that act which is in the nature of an act of state, it becomes an act of state.
But I mean, as between two sovereigns, which was the situation in Kamachi, the point was that their relations could only be regulated by reference to international law, which was not the law that the courts of the United Kingdom administered or enforced against its own government. That's really the ratio of Kamachi, isn't it?
Yes. But the question then becomes, what acts of a Crown servant can be characterised as exercises of pure power, as opposed to ones that purport to justify themselves under municipal law? That is a choice for the courts. And in respect of those acts, the consequence will be that the only law that is going to govern those acts is international law. Yeah. And to the extent that you have a complaint, you must take it up through your government and diplomatic channels with the foreign state. That's exactly what the consequence of Burren and Denman itself was. It was left to the individual to see whether or not diplomatic channels would work as a means by which to remedy the wrong. But the fact that the test is one of whether or not the act in question is one which, when the Crown is acting in its sovereign capacity, for example, in the context of treaty making, war, here, the taking of property of another sovereign, whether in that context the act was done subject to municipal law or as an exercise of pure power. Now, where it's treaty making, it necessarily is not done subject to municipal law. And then the question becomes one of whether or not acts in connection with those kinds of sovereign acts are themselves done pursuant to municipal law.
Well, in the case of the Queen Dowager, she no doubt had ordinary civil rights to her property, but they were simply overridden. She was someone, in Lord Wilberforce's terms, its acts done in the course of relations with another state, including its relations with the subjects of that state, and she was one of the, in those terms, subjects, I suppose.
Yes, and equally, Burren and Denman can be seen as acts done in the course of one's relations with another state, including the subject. And the subject here was the owner of the slave. Can I give the court some references to some other cases, because I don't think we've got time to go in detail through them. Two cases in Volume 5, and these are cases which in our submission the courts are taking an approach to Burren and Denman as being a case concerned with justiciability and not as having established a defence. So Musgrave and Polido, which is at 535, 10562. And apart from the head note, we can see that Burren and Denman is cited in argument at 10564 and 10565. I don't want to get bogged down with these cases, as I say. So if I can just give the references. And 10572, there is an analysis that begins of the Indian Act of State cases. 10573, the point is made that the court always looks at the nature of the act to see if it has the character of an act of state. So we have Burren and Denman and the whole, and cited to them, they're well aware of it, but what the court decides is you always look at the nature of the act to see if it has the character of an act of state. Pole and the Lord Advocate, that's in the same volume at tab 40, 10764. This was decided in 1899. Again, head note, and then I think I'm going to have to
Sorry,
briefly so that I can show.
this is Pole at flag 40.
This is Pole, tab 40. So apart from the head note, it's a strange judgment set out in a rather strange way, but if the court then turns to 10767, we have at the bottom of that page argued for the respondents. If the court just marks up there that bottom paragraph and then footnote 4, we can see there's reference to Burren and Denman. And then if the court on the next page, 10768, looks to the last line, on the 5th of November 1897, the Lord Ordinary sustained the first plea when law for the respondents refused the note. And we see the star, and then underneath we can see the star cross-referenced and the opinion. And if the court can just read that opinion, in our submission, that opinion sets out a statement of a very broad doctrine of non-justiciability, and it's a possible interpretation of Burren and Denman, but as a rule of justiciability, to the effect that every act of the sovereign, whatever its nature in respect of a foreign state or its subjects, is an exercise of pure political power, not subject to municipal law. And then next two cases are in volume 3. First is the case of Doss, which is at tab 25. And this was a case where Oud, the territory of Oud, had been annexed again by the East India Company. And 10028, at the bottom, halfway down the page, the argument was put by the Crown that the acts were an exercise of public and political power. Once ratified, they became acts of state, referring to Burren and Denman. It was argued that Burren and Denman is irrelevant at 10034, three-quarters of the way down the page, by the plaintiff. And at 10039, judgment of the Vice-Chancellor commences, and the relevant parts are at 10044. And the Vice-Chancellor analyses three cases: the the Byrne case, and then the Nabob of Carnatic case, which had nothing to do with ratification and the defence, or any conception of the defence, and Camachi. And in all the cases that are analysed, the focus is on the nature of the act and whether it was a sovereign political act. No analytical distinction is drawn between Camachi and the Nabob case and Byrne and Denman.
So what are we getting out of all this?
That contrary to what has been, or to what Mr. Justice Leggett found or the Court of Appeal found, it is not the case that this defence has been identified by the courts repeatedly over the last 150 years. On the contrary, when the courts have looked at this, they have more often looked at it as a rule of justiciability or as an aspect of justiciability rather than as establishing a defence. And the final case on this is Johnston and Pedlar, which was a House of Lords case decided in 1921. And this was a case of an individual who was interned here in the United Kingdom. And so the question arose as to whether or not there was any room for the application of a doctrine of Crown Act of State in the domestic plane.
I mean, when you say it doesn't create, it's been viewed as a non-justiciability, those words aren't used. What is said in DOS is the act was an act of sovereignty, which is an act of state. It doesn't create any civil right whatever. I mean, again, what do you mean by non-justiciability? Do you mean that the inherent nature of the situation is not judgeable, or that's again
Exactly.
you use
on the basis it creates no civil rights because it is not an act that took place in the plane of municipal law. Yeah. It is an exercise of sovereign power.
Yes, but it has it's not just as non-justiciable. It's treated as meaning that there is no civil right. So you could view it as a defence, or you could view it as eliminating any right. It prevents there being any right. Does it matter which way we look at it, actually?
Well, it matters in the sense that is Byrne and Denman being conceptualised and conceived of as something that is different from the Camachi cases, the Nabob cases, which clearly focus upon whether or not what is the act in question sounds in municipal law at all, or is a sovereign political act that is above and out with domestic law.
Yeah.
That is a justiciability rule.
Yes.
And what
It all
we are
comes
told,
back to what do you mean by a sovereign act in this context, how wide an interpretation you give it. That's what we're ultimately arguing
yes,
about.
Exactly. But there is a difference between a conceptualisation of it as the defence. We are told that the Byrne and Denman, so Byrne and Denman can be conceived of in the way that I've identified. The broadest way that it can be perceived is as having effectively held that any act of the sovereign abroad is an exercise of political power that is not justiciable in the municipal courts. Or it can be perceived of in the way that Mr. Justice Leggett did, yes, and the appellants have contended for, as not having that effect, but merely operating on the basis that where the act in question is ratified, whatever its character, it simply means that the cause of action that you might have is not...
I mean, the difficulty, you come back to the very first exchange, I didn't see Mr. Eadie as advancing so broad a proposition, and indeed it makes it clear that he doesn't suggest that there's any defence to certain types of tortious conduct, inflicting injury, as I understood it. You understood it slightly more narrowly, but his references in his case to the need for a sovereign aspect to the defence in tort seem to me to mean that you're arguing on territory which isn't really in issue.
Well, this is the point that I made. This is the point I made at the beginning. But what we have to look at here is what is... So the defendant's argument In their cases, there was a defence that was established by Burren and Denman.
Yes.
At the time, it had this character. He is now saying its character must be seen to have evolved and changed. But it evolves and changes in an incremental way, he says. Our submission is there never was a defence in the first place. It was a rule of justiciability. That rule of justiciability, or the approach of the courts to justiciability, has fundamentally changed since then.
Yes. Right.
And therefore, what we have to ask ourselves is whether or not there is any room for the courts now to develop a rule of abstention, as it were, or whether what the court is engaged in is an exercise of taking a defence that already existed, a rule of abstention that already existed, and analysing it in modern conditions. The defendant's cases, there was a defence that existed. It was of this character, see his case, i.e. it was a rule, a defence that arose whenever the executive was acting pursuant to a policy, or whenever the executive ratified an act done in the context of its foreign relations abroad. That's the very nature of the defence that the appellants argue Burren and Denman created. And to look at what the appellants are now saying is the nature of the defence is, in our submission, not the right approach, because we're asking, was the defence which they allege Burren and Denman created ever created? Was there ever a rule to the effect that ratification by the Crown of any foreign act means that it can no longer be adjudicated, or the wrong thereby done can no longer be adjudicated upon the courts? And in our submission, there never was that defence.
Ms. Kaufmann, looking forward, I wonder whether you would be kind enough to help me, and I'm sure it's my fault, to identify where you disagree with what Mr. Eady yesterday said about the components of the principle. Forget labels. He said there needed to be a sovereign act, number one. He said it needed to be in the course or conduct of foreign relations, number two. He said the act had to take place outside the UK, number three. He said the act had to be of a nature to qualify as an act of state, number four. And then, when later Lord Mann said, shouldn't we also be looking at the legitimacy of the act under international law, perhaps not an obligation to do it under international law, but an authorization of it, or not being in breach of international law, my note, which rather confirms what you said at 10:30, was that Mr. Eady in effect said, yes, we could look at it that way. So if you add that as number 5 onto 1, 2, 3, and 4, where's the difference between the two propositions with which we are being intrigued?
The essential difference is that it's number 5, as in, if you can constrain the acts described in 1 to 4 as being done in accordance with international law, then that gives the necessary legitimacy to the rule of immunity, and it gives the necessary proportionality to the rule of the immunity, because it ties acts undertaken in the course of military operations to the justification for the immunity. And the justification for the immunity is that the state, where it is acting on the international plane, under powers given to it or obligations imposed upon it in international law, it should not be trammelled by another body of law which will cut across it acting in accordance with those international powers and obligations. But what's critical there is the critical constraint which gives the rule or circumscribes the rule and ties its limits to its justification, is that the act must be done in accordance with those international law powers and obligations. Because otherwise, if it's simply the fact that the acts are taking place on the international plane, which is what the appellants contend, what I had understood them to contend for before the conversation that took place yesterday morning where it became less clear. If it's simply that the fact those acts take place on the international plane is enough to say in respect of sovereign acts that are conducted in relation to military operations abroad, the court must not adjudicate upon a tort claim. One is working in an incredibly unbounded field, because what are the acts in question? What acts pursuant to military operations are qualifying as these sovereign acts? So we have the sovereign act that he identified, declaration of war. Well, we're obviously not dealing here with the declaration of war. We are dealing with acts done pursuant to a declaration of war, a long way down the line, yes, in the exercise of military operations, but what makes those sovereign acts, as opposed to another set of acts being sovereign acts, and what is the justification? We have to look at the justifications for the immunity, and when we look at the two justifications, I will come to this afternoon, this is a summary, but when we look at the two justifications that were offered, the one voice principle and the international plane arguments, they simply cannot justify an immunity of such broad scope, because a condition that the acts are done in accordance with the international law obligations meets the mischief and does so in a proportionate way. And it operates.
The difficulty is, I suggested it, and I've got an open mind, but the difficulty is that it's not actually easy to reconcile with the line of authority from which any principle comes, because it would be inconsistent with Buren and Denman, where presumably, where it's clear that what the British government ratified was contrary to international law. One could say, well, the British government policy was obviously, in ratifying, was based on its disapproval of slaving in general, but it ratified an act which involved effectively a wrongful invasion or wrongful destruction of property in somebody else's country.
But that's exactly...
That must be contrary to international law. And similarly, Kamachi, would it have been open to the Dowager to say, hold on, this act was contrary to international law, I must receive compensation. You are asking, if you introduce this qualification, domestic courts to adjudicate upon the conduct of the United Kingdom in terms of international law. Now, we may do that in relation to Article 5, because that operates at an international law level, and it may be part of the Human Rights Convention scheme, but it may be more difficult just to import international law into domestic law.
Well, two answers to that.
In this context.
Two answers to that. Firstly, the Buren and Denman decision, the Kamachi decisions, were decided 150 years ago in a completely different constitutional era, where the relationship between the courts and the executive was fundamentally different. And that's why we started from the proposition that one has to bring this doctrine and its application into a modern constitutional setting.
Yes.
In those days, the acts in question fell outside, or they fell in that Category 1 Shergill non-justiciability category. They were firmly situated there. Those self-same acts today would not be.
Is that consistent with the CND decision?
Yes, the CND decision was another decision where in the analysis in Shergill, it was looked at as a decision which was about whether or not there was a domestic foothold. So looking at her property today, if the court were to look at the taking of her private property today, one has to ask, would the court simply say this is a political act that we are simply incapable of judging, or would it say, actually, this is something which interfered with her property rights, her private property rights under her own domestic law, And we are in a position, in terms of our competence, to exercise jurisdiction. So that's the first point. It's a profoundly different constitutional era. We should not approach this by, on the basis that this court is bound by conceptions of justiciability that existed 150 years ago. That's why
Nissan suggests that the Queen Dowager, at any rate then, might not have done any better in the 1970s than the Queen Dowager did back in whenever it was, in the 19th century.
But again,
or it could be argued the other way, couldn't it? It could be argued that Nissan suggests that the distinction that you're putting forward would be drawn today between annexing the state and annexing the state's property and taking private property, which was not necessary in order to effect the annexation, which I think is the point you're making.
Yes.
And Nissan could be read in exactly that way.
And that's the critical point, is that we have to look at these cases through a modern lens and say, what would, recognising that those Category 1 cases haven't been decided upon and determined, but the exercise the court would have to undertake is to ask itself, is this a Category 1 case, or are some aspects of it Category 1, and is the remainder justiciable if there is a domestic law foothold? But that's the framework we have to look at it in, by reference to the modern relationship between the executive and the courts in the field of international, the Crown's international relations. And I'm afraid the second point that your lordship made has completely gone out of my mind.
Well, as it has mine. So.
Well, the point that my lord made, and in fact, this is the point that, according to my note, you made to Mr. Eadie yesterday, as I understood it, and I may have got it completely wrong, this is not impossible, is that if one's looking at a fifth requirement of compliance with international law, should that be judged by international bodies rather than by domestic bodies? That is the point that he put to Mr.
Yes.
Eadie, and Mr. Eadie gave an equivocal answer.
Yes. Well,
He said, well, yes, maybe we'll deal with that later, but I've been looking for it later.
it's an incredibly important point, and I'm sorry it went out of my mind, but it's incredibly important. And our submission is, the case law is replete with the domestic courts looking at international law and resolving international law questions when it has to. See the Ahmed case that we looked at just earlier. Where a really close parallel to this situation is, for example, the Oppenheimer or the Kuwait Airways case, which operates in the field of foreign act of state. So there, the court will say, has what has been done by the state, or does enforcing the law which the state wishes us to enforce in these proceedings contravene international law obligations? It will ask itself that question, and if it concludes that it does, then it won't enforce that law. Now, that is not enforcing international law on the domestic plane. It is looking to international law to make the determination as to whether the foreign law will be enforced.
Well, what it's doing, surely, is it's very well illustrated by the Kuwait case. It's saying that if you have a doctrine, and this was about foreign act of state, which requires the English courts, in the interests of its international relations, to abstain from criticism of the conduct of a foreign sovereign state, that may be qualified if the conduct of the foreign state is repugnant to fundamental principles of international law which govern relations between states. It's a consideration of some importance, but it's peculiar to that kind of case, where somebody is, the point about foreign act of state is it's a doctrine based on relations between states which can't actually be decided without looking at international law. What you're suggesting is that we should devise a rule which would require the English courts to do that which in the ordinary course they will not do, namely pronounce upon the international lawfulness of the United Kingdom government's acts?
The Foreign Act of State doctrine, in the Kuwait Airways case, the courts pronounced upon the lawfulness in international law of the acts of the Kuwait government.
Yes.
It did that in order to determine...
The Iraqi government.
Sorry, the Iraq government. And it did that in order to determine whether or not it was going to give effect to the law. There is no distinction in my submission. What this rule of immunity, if bounded in the way we submit it should be, does, is it requires this court to look at the obligations that are imposed upon the United Kingdom government under international law, to address whether there's been compliance with those obligations, and to use the answer to that question to determine whether or not it should give effect to foreign law. That's precisely the same exercise that is undertaken in the Kuwait Airways case. Has there been compliance with international law? If there hasn't been compliance with international law, if in fact this law contravenes it, we will not give effect to it. There is, in my submission, there isn't a distinction, and in both situations, the court is not enforcing international law, it is using international law as the measure by which it decides whether to enforce a municipal law.
Is that a curious form of logic? In order to decide whether this defence is available, we have to consider whether there's a breach of international law. We consider there is a breach of international law. Therefore, the defence is not available. Therefore, we look now at Afghan law. Is that a curious and illogical progression, or is that perfectly legitimate?
In our submission, it's a logical progression if one looks at what is the justification in the modern world for our courts to step back from enforcing the rule of law and providing access to the courts. If one analyses it through that prism, and that has to be the starting point, as we'll see with Jones and Caney, then the answer is, in our submission, a logical answer. And it is an approach which is already applied by the courts in relation to foreign act of state. So there's a model there. There is a clear model, and it's simply applying it in a different context. And in our submission, not only is it a logical approach, it's the only one that's proportionate. And it's the only one that is consistent with what our courts are doing in other areas of the law. So where they are looking at these self-same acts through the Human Rights Act, where they are looking at these self-same acts through habeas corpus, or where they are looking at these self-same acts in judicial review, even though they're taking place on the international plane, they're doing that in order for the fact that those acts are taking place on the international plane to justify the courts in standing back from giving effect to the rule of law and the right of access to the court in another sphere of law. There has to be something more than the simple fact that these acts are taking place in the international plane. And what is that something more? That something more is the need to ensure that the executive can get on and do what it is obliged and empowered to do in international law. But a check on...
I mean, my Lord's thought it seems to me worth a further question or probe. Why is it logical? Because in the Kuwait and Iraqi Airways type situation, it's perfectly simple. You're applying Iraqi law, the place where the conversion takes place, and the Iraqi government relies on its own legislation confiscating the Kuwait Airways fleet, whereupon the British courts say that's not legislation we can recognise because it's contrary to Security Council resolutions, contrary to international law. So you just eliminate that bit of Iraqi law. You still remain within the rest of the scheme of Iraqi law. Here, because of a failure to comply with what is said to be one of the conditions of Act of State, you move into a system of law which you wouldn't otherwise be in, rather than provide a remedy for breach of the international law obligation. That seems a bit odd.
But
I mean, the natural thing, if one of the conditions is that you comply with international law, you'd expect, if you didn't comply, that there would be a domestic remedy for that, not that you would then suddenly acquire all sorts of rights under Afghan law.
But it's not about acquiring the rights under Afghan
No, I see.
law.
It's your
The rights
idea is they exist,
The
basically.
rights exist. It's about disapplying those rights. It's about shutting somebody out from the access to the court that they would otherwise have. Can I just quickly finish off on the defence? As conceptualised, or as the appellants say that defence existed post Burnham and Denman. And the last case, as I said, that I wanted to refer the court to, not to look at now, is the Johnston and Pedler case. That's in volume 3, tab 28, 10098. And the relevant passages are in Viscount Finley's judgment 10107. And sorry, sorry, bear with me a moment. So if the court can then just mark up to read the whole of that page 10107.
So what are we getting in a sentence from all this? There's a lot of passages in this case.
Yes, I don't want the court to read it now, but
Just tell us in a sentence what we're going to
so
get out.
again, the point of this case and the reason for referring to it is in our submission, what it shows is contrary to what the Court of Appeal held, contrary to what Mr. Justice Leggett held, the courts have not looked at Burr and Denman as a case establishing a defence. They have conceptualised it as a justiciability issue.
But it's a very broadly stated principle on page 10107, isn't it?
It is a very...
Subject to qualification in the case of acts committed abroad against a foreigner. Open to the defendant to plead that the act was done by the orders of the British government, or after it had been committed, it was adopted by the British government, in any such case. So that's not focusing on the quality of the act at all. It's just focusing on the fact that it was authorised or ratified by the British government.
So again, I mean, what it's focusing on is any act. So this was a third conceptualisation that's possible in relation to Burr and Denman that I discussed before. You can look at it as having massively broadened the scope of the Act of State doctrine to remove it from simply those sovereign acts such as treaty-making, annexation, to any act committed or on behalf of the Crown abroad. And Viscount Cave, we don't rely upon him because he didn't make it clear as to what the precise basis of the doctrine was. Lord Atkinson, 10114, at the bottom of the page, cites the Camachi case as the best definition of it, and then looks at Burr and Denman, but subsumes Burr and Denman into the analysis of the doctrine given in the Camachi case. So again, sees it as simply about the effect of ratification. And Lord Sumner, at 10126, halfway down the page, if the court can mark that up, halfway down the page towards the bottom, looks at Burr and Denman, then there is a passage...
what page was it, sorry?
Sorry, 10126. So paragraph halfway down the page, looks at Burren and Denman, and then there is a whole passage to 3/4 of the way down the next page, 10127, reviewing how the municipal courts came to exercise jurisdiction over the Crown within its territory, and then a further reference to Burren's case on 10127 at the bottom over a third of the way up. And in our submission, this analysis is an analysis which is one of justiciability rather than there being a defence that the Crown is not subject to law. So far as Nissan is concerned, as Lord Neuberger observed yesterday, everything said about the defence in Nissan was entirely obiter. Two of the judges, Lord Pearson didn't even make reference to Burren and Denman at all. Those judges who did refer to Burren and Denman treated the case very differently. And it is impossible to gain any sense of how they conceptualised Burren and Denman. Certainly that's so in the case of Lord Reed and Lord Morris, whose complaint was about the unholy mess of the state of the case law because the doctrine was used in so many different ways. And Lord Wilberforce, as we've seen, all he did was to make a bold statement to the effect that the passage cited from Wade conflated two distinct conceptions of the doctrine, a rule of justiciability and the defence, but he didn't for a moment analyse the origins of the defence and trace the case law in which it had been referred to. So in our submission, Nissan doesn't provide a basis upon which this court is compelled to conclude that this defence does exist and has existed. The case law since Nissan, reference was made to the Buttes case, that's in volume 2, tab 16, 9630. That's 9672G. Lord Wilberforce says, in the first place, we can segregate that version of Act of State which concerns action by an officer of the Crown taken outside the country against foreigners otherwise than under colour of legal right. So that's using, interesting, the language of justiciability there. It's not done under colour of legal right. And the classic example is Burren and Denman. But there's then no further analysis whatsoever of the nature of the cases of Al-Jeddah, both at first instance and on appeal. Everything again said there about the defence is entirely obiter. The case was decided in both instances on different grounds. So anything said about Act of State altogether was obiter. But when Act of State was analysed in those cases, it was on the basis of the justiciability principle. And again, all that was said in relation to Act of State was to identify, by reference to Lord Wilberforce's judgment in Nissan, that there are these two different conceptions. So, again, no weight can be placed upon that, on those two cases. As far as the commentaries are concerned, yes, one finds commentaries that support the existence of the defence, but equally one finds commentaries to the opposite effect. And so that really doesn't take one any further. Again, for your lordships and my ladies, note, Kieran Lawson, it's worth actually reading a fair bit of the passages. We've extracted some in our case, but at 8 tab 74, 11,713. just for the court's note, I will refer to some passages that the court can read. The whole of the first page, 11714, and then from page 297 all the way down to 11717, just above the heading treaties. And
Well, he says, in truth, all the Crown does in the sphere of foreign affairs falls within the categories of acts of state. Is that what you're...
yes, so he looks at Burren and Denman and sees Burren and Denman as extending the doctrine, but not on the basis it creates a defence.
Yeah.
So here he says, in the first page, whereas, halfway down the page, whereas in respect of acts done within the realm, the courts are not obliged to abandon jurisdiction at the mention of prerogative. They cannot inquire into the validity of an act of state. Doubtless the Crown is bound to act in accordance with the dictates of international law, but the obligation can only be enforced through diplomatic means. The point was brought out clearly in the Kamachi case. This immunity would be illusory if it were not shared by agents of the Crown. Therefore, a plea of act of state may be successfully raised wherever an action in tort is brought by a foreigner without the allegiance against a person who has acted under prior authorisation. This is the true point of the rather unsatisfactory case of Burren and Denman. So it's simply to apply through the ratification process the act of state doctrine to the servants of the Crown. And we can see he then quotes Salomon on page 11716, doesn't so much as mention Burren and Denman, and that's a case again about justiciability.
1176.
Yes.
I see. Yes, I see. Yeah.
I'd also ask the court to read Wade, because in our submission, Wade's conflating of Burren and Denman and the other body of case law was deliberate on his part. He was describing a single rule of justiciability and looking at all those cases in respect of it. And finally, Kingsbury, 8 tab 75, 11718. And the first 3 pages so for those reasons we submit there never was a defence, and there has only ever been, the doctrine has only ever been conceptualised in terms of whether foreign acts of the state are justiciable in these courts in a Buttes-Gas narrow conception of that term.
I don't think we've got a title page to Kingsbury, have we?
No, I'm afraid I don't think we do.
The index tells us
Yes.
a bit, namely that this is a 1910 article.
Yeah, American Journal of International Law, it says.
I'm sorry about that. My lords, my lady, I'm looking at the time.
It's 5-2. I'm afraid that clock
It's
is...
5-2.
I'm afraid we especially arrange it to deceive counsel. Sometimes it's slow, sometimes it's fast. Sorry about that.
The next topic is, if there was a defence, if we're wrong, if Burren and Denman established that defence, did it survive the Crown Proceedings Act? And our case on that is set out at page, in the core bundle, page 12309 to page 12320, and I suspect that I'm going to ask the court to read that and refer to that, but I will just quickly highlight the key part of our argument. So the first point to make is, although there have been observations by the in some of the commentaries and a passing reference by Lord Morris to the introduction of the Crown Proceedings Act in Nissan, there hasn't actually been any analysis by the courts about whether or not, or how it impacts upon the defence. So
Can I just get clear? I mean, we were talking about the components of the defence, and in particular the issue, possible issue, about the need to comply with international law, international human rights law. Is all that subject to the point that you're just about to come on to, namely the 1947 Act?
no. So our submission is, really what the court is doing now is starting from scratch and asking whether or not there should be a rule of abstention. And the reason we submit that is because we say there never has been that rule of abstention before that operates. Either there never was a defence, it was just justiciability, and see Shergill, these matters are now justiciable, or if it wasn't a defence, if there was a defence, it's been extinguished by the Crown Proceedings Act back in 1947. And so if the court is going to hold that there is a basis for disapplying foreign law in the context of military operations, it's got to start from scratch to justify it. That's the argument. But as I've accepted, ultimately it doesn't necessarily make a great deal of difference, save that if the court starts from scratch, there's no question it's got to proceed on the basis of justifying this rule by reference to current conditions as being necessary and proportionate in pursuit of a legitimate aim, whereas the court might accede to Mr. Eadie's argument that if there was a defence, then it's incumbent upon the court to develop it incrementally as opposed to firmly located in a bedrock of justification and legitimacy in current conditions. So,
Is that a convenient moment? Or
yes.
You've got, I think, on the timetable an hour and a half between you and Mr. Hammer. We're doing okay, are we, on that?
Yes, we are. Yeah, Mr. Hammer, I think it's going to be about 10 minutes or so.
Fine. Okay, that's fine. Thank you very much indeed. We'll thank you very much. Resume again at 2:00. Court's now adjourned.